thank you for returning from lunch. We hope you had some productive conversations with your peers. My name is Sophia Bunch, and I have the honor of serving as the managing editor of Volume 54 of the New Mexico Law Review. I want to make a big shout out to Chanel Daniels for bringing us all here today. Thank you, Chanel. And I'd also like to thank our panelists and our 2 keynote speakers for getting us started this morning. I have the honor of introducing our 3rd keynote speaker of the symposium, Professor Joanna Schwartz. Professor Schwartz is a professor of law at the UCLA School of Law. She's a leading expert in police misconduct litigation, which is evident through her many publications. Her most recent publication, Shielded: How the Police Became Untouchable, is available for purchase and signature today. She's also been published in a variety of big-name publications such as the New York Times, the Washington Post, Examining Qualified Immunity, Financial Settlements, and Judgments Against Law Enforcement Officers, along with civil rights protections. Additionally, Professor Schwartz has been featured on a variety of news platforms discussing her research. As Mark Baker noted, Professor Schwartz is part of the history of the New Mexico Civil Rights Act, testifying before the Civil Rights Commission before it was passed. Please welcome Professor Schwartz to discuss constitutional recalibration and lessons from the Civil Rights.
Thanks so much for that really warm welcome and introduction. I echo the thanks to Chanel Daniels for putting on this extraordinary event with her team of folks at the Law Review and at the law school. And I want to echo the earlier comments today by saying that it is really an honor to be able to be here and speak to you all and to see so many people who are engaged with this issue and have participated in the passage and effectuation of this act. I also want to echo the comment that you all are likely far more expert than I about the precise terms of this act, but I want to offer in my comments today some thoughts about what you all have done that I can see from my vantage point and its importance, and also lessons that I hope other states and legislatures can take from New Mexico. So, on and off over the past several decades, and with particular force and urgency since George Floyd's murder in May of 2020, we've been engaged in a national conversation about the scope of government misconduct and the need for meaningful accountability. The power to sue for constitutional violations has long been one of the only means of getting some measure of justice following government misconduct, and it is, in my view, among the best of the available alternatives. Not that it solves every problem, not that it is the only type of reform that need be passed, but when you're thinking about how to get some measure of justice and accountability, how you can have some hope of preventing something similar from happening to someone else in the future, it is often through bringing a lawsuit that families and people who have been wronged by the police or other government officials can find some measure of that justice and accountability. For a long time, as other speakers have noted, people who have had their rights violated have often turned to the federal courts to get some measure of justice in these cases. And they've looked back to what was referred to earlier as Section 1983 to seek that relief. Now, for those who don't know, Section 1983 became law 150 years ago, after the Civil War, during Reconstruction, when Black Americans were being tortured and killed, primarily though far from exclusively in the South, and state and local government officials were either participating in that violence or doing nothing to stop it. And Congress, in 1871, faced with these stories, passed what they referred to as the Civil Rights Act or the Ku Klux Klan Act, the law that became Section 1983. And the law was passed, the Congress found the need to pass this law because not only were state officials participating in this violence or standing idly by while it happened, state courts were considered very hostile places for Black Americans to bring claims. In most states, they were not even allowed to testify, so it's hard to imagine how they might have succeeded in a suit. In the view of the Congress people, the congressmen who supported the Ku Klux Klan Act, the federal judges and juries were, in their view, better able to rise above the prejudices or bad passions or terror than their state counterparts. And so this was the hope and promise of Section 1983. As an earlier panelist noted, Supreme Court decisions immediately following passage of this statute essentially took all the power away from Section 1983. It was reinvigorated 90 years later in 1961, where the Supreme Court recognized for the first time that there was an ability to sue law enforcement, in that case, for violations of federal constitutional rights. And at that moment, in 1961, the doors of the federal courthouses opened for these kinds of constitutional claims. But over the past 50 years, there have been multiple barriers read into the body of Section 1983. Qualified immunity, but many others as well that I'll speak about in a moment. And all of those governmental protections read into the text and intent of Section 1983 has made the statute a mere shadow of its aspirational self. As it currently operates today, I think Section 1983 would be a great disappointment to those in Congress who supported the statute's passage a century and a half ago. In 2021, New Mexico, in my view, offered a groundbreaking response to calls for more meaningful constitution and more meaningful constitutional protections, and that is the New Mexico Civil Rights Act, which we are all brought here to talk about today. Section 1983, remember, was passed 150 years ago to make up for inadequacies in state court protections. And now here we are, 150 years later, where New Mexico needed to pass a Civil Rights Act to offer an alternative remedial framework that makes up for those inadequacies that we have in the federal system. I'm thrilled that we are here today to try to better understand how the Civil Rights Act came to be, how it's currently being applied, open questions about its scope and power, and possible future amendments to its provisions. And I'm thrilled not only for today's symposium, but also for the forthcoming articles that are going to be dealing with these issues in more depth. And I'm thrilled, as I said, that so many here in New Mexico who engage with civil rights litigation in one way or another are here and participating and listening to this conversation. And I've already learned a tremendous amount about these issues from the discussions we've had. I know I will continue to. And I hope, as some sort of modest return, I can situate New Mexico's Civil Rights Act in a somewhat broader context. So I've spent the past 20 plus years, first as an advocate and now as a law professor, trying to examine the ways that civil rights lawsuits make their ways through the courts across the country, and these many barriers to relief in these cases, and possible adjustments that could usher in a better system. And I see New Mexico's Civil Rights Act as a really important effort to recalibrate civil rights protections in important ways that respond to long-standing and pressing concerns I and others have had. And given the current state of affairs in Congress and in the Supreme Court, I think that state-level reforms like those enacted by New Mexico are the best and also the most realistic hope for this kind of constitutional recalibration elsewhere. So I view New Mexico as a real bellwether. And in my view, both the substantive provisions of the Act and your process of enacting and implementing the Act offer valuable lessons for other states across the country that are or may consider this kind of recalibration in the future. So I wanted to take my time to describe 4 lessons, important lessons that I think lawmakers and advocates around the country should learn from New Mexico, and lessons that I hope New Mexico continues to embody in the future as they are leading this path. The first lesson is that qualified immunity is just one piece of the puzzle. Qualified immunity has taken the lead in conversations about the failures of police accountability. Those conversations seem to focus almost exclusively on qualified immunity. And to be clear, I am no friend of qualified immunity. I think it deserves all the criticism that it has inspired. This is a doctrine that, yes, began in 1967, 6 years after the Supreme Court recognized the right to sue, and began as this good faith defense when officers violated the Constitution. An earlier panelist mentioned that this was based on some historical common law defenses. There's actually a lot of good historical research now that suggests there was no intent that any state law immunities be read into what Section 1983 is. Even if there were, those prior, what we had going on in state courts in 1871 looked nothing like qualified immunity today. It has morphed since this good faith defense into an objective standard that requires that allows qualified immunity so long as officers haven't violated clearly established law. And the standard for what amounts to clearly established law has gotten narrower and narrower and narrower, such that a plaintiff trying to bring these cases has to find a prior court decision with nearly identical facts. The justifications for qualified immunity, which I'll talk about in a moment, have been concerns about officers being bankrupted for good faith mistakes. I don't believe those justifications hold water for reasons that I'll say, but what those the qualified immunity defense has been understood as balancing the need to offer people whose rights have been violated a meaningful remedy against the interests, or balanced against the goals of not subjecting officers to cases where the law is not clearly established. But what's actually coming out of the courts are cases where people have had their constitutional rights violated, sometimes grievously, and have gotten no relief simply because those officers had the good fortune to violate someone's rights in ways that had not with precision been previously held to be unconstitutional. Officers have been awarded qualified immunity after stealing $250,000 during a search, releasing a police dog on a person who had indisputably surrendered, and kneeling on the neck and back of a man named Tony Timpa in Dallas for more than 14 minutes until he died, in very much the same way that George Floyd was murdered in May 2020. So I have a lot of dislike for qualified immunity. But qualified immunity is wrongfully, in my view, often depicted as the only shield that makes it difficult for people suing government officials to get the justice that they seek. Instead, the challenges of suing government and getting meaningful relief should be blamed on a whole slew of legal doctrines, rules, and practices. And if you want to learn more about them, you can read my book. Happy to sign it at the cocktail hour. And you're going to need a drink when you read it. But what you'll see, and what I've studied and what I talk about is that barriers put in place by the Supreme Court make it very difficult to find an experienced civil rights lawyer in many parts of the country, to plead a plausible complaint with enough facts to get past the Supreme Court's plausible pleading standard, to prove a constitutional violation, because the Supreme Court's description of the Fourth Amendment allows that a person who has done nothing wrong can be stopped, searched, arrested, shot, and killed, and not have their constitutional rights violated, so long as what the officer did was reasonable in the moment, not from 2020 hindsight. The standards, as we've talked about earlier today, under Monell, this municipal liability standard, make it very difficult to put wrongdoing, put liability on local governments, who, as one of the prior panelists mentioned, are often those who are the most responsible for allowing their officers to do what they have done. And in fact, I've done research that suggests that it is more difficult to establish municipal liability than it is to get past the barriers of qualified immunity. And it's also very difficult under federal law to have standing to seek forward-looking injunctive relief. And if that's not enough, even when a person can get past all of those shields and secure a settlement or judgment, decisions by state and local governments across the country mute the deterrent effect of those awards. It's local governments, not police departments and not officers, that make those payments, that bear those financial costs. Those cases rarely have any impact on whether an officer is disciplined or fired, and many police departments make no effort to gather information from or learn from those suits. I told you you'd need a drink. When conversations about police accountability and reform focus exclusively on qualified immunity, they overlook the protections that are offered by these many other doctrines, rules, and practices. And they also overlook the possibility and benefits of enacting reforms that would address those other barriers to relief. Thankfully, those who drafted and passed the New Mexico Civil Rights Act did not make this mistake. The Act does prohibit qualified immunity as a defense when people sue for violations of the state constitution, and given the outsized public focus on qualified immunity, it's perhaps unsurprising that this aspect of the Act has received the most attention. But the Act doesn't stop there. It additionally addresses these challenges of establishing government liability by waiving the state's sovereign immunity and requiring that claims under the Act be treated as claims against the local government employers. To encourage more attorneys to bring meritorious cases under the Act, it requires that attorneys be paid for their time when they prevail. And it addresses concerns that local governments don't learn from the lawsuits filed against them by requiring that local governments keep a record of all settlements and judgments paid under the Act, as well as a copy of the complaint in those cases. Now, legislatures and advocates in other states may come to different conclusions about which aspects of the civil rights ecosystem are top priorities for reform, and qualified immunity may well always or often be at the top of that list, but it shouldn't be the only item on the list. And I commend New Mexico and their Civil Rights Act for understanding and making clear that qualified immunity is just one piece of the puzzle. Lesson 2. Reforms are knobs, not switches. So let me explain what I mean. When discussions of police accountability focus solely on qualified immunity reforms can seem like an all or nothing proposition, an on-off switch that flips one way or the other. Either we have qualified immunity in full force or it will be gone in its entirety. But because the relationship between constitutional rights and remedies in court isn't determined solely by qualified immunity, but instead by interactions between a whole host of laws and practices and rules, police accountability reform should be understood not as a switch that goes on and off, but as a series of knobs that can be adjusted to make a better system. Some have suggested that that's what the Supreme Court is already doing, adjusting these various constitutional and remedial doctrines to create a form of equilibrium. Now, if that's what the Supreme Court's intending to do, create equilibrium, I don't think they're doing a very good job. Instead of creating equilibrium, I think they always, or almost always, give undue preference to the interests of government officials when they adjust those knobs. And if I may make a Spinal Tap reference, those knobs seem to go all the way up to 11. The New Mexico Civil Rights Act aims to recalibrate constitutional protections by turning several of those knobs, including the knob controlling qualified immunity and state and local government liability, in the other direction. Because these are a set of knobs to be adjusted instead of a switch to flick on or off, different states can and should adjust those knobs in different ways to achieve what they consider to be the right balance and what they consider to be the politically palatable one. And the fine-tuned nature of these adjustments becomes apparent by comparing, for example, the laws passed in New Mexico and in Colorado governing civil rights against government officials. So both the Colorado Act, I should say, side note, Colorado created a state civil rights act that is similar in some ways, which I will describe, to the New Mexico Civil Rights Act. They passed it in the summer of 2020. And both the Colorado and New Mexico statutes create a right to sue for violations of the state constitution without qualified immunity. Both allow for attorney's fees for prevailing plaintiffs. But the states differ in who is called upon to answer those claims. In New Mexico, as we've heard, the claim is brought against the local government. In Colorado, the claim is brought against the individual officer. The state's laws differ on indemnification rules. In New Mexico, local governments are obligated to indemnify officers for all conduct in the course and scope of their employment. In Colorado, local governments are also obligated to indemnify for any conduct that doesn't result in a criminal conviction. However, the officer in Colorado, if their jurisdiction finds that they have acted in bad faith, they can be required to contribute up to $25,000 or 5% of settlement or judgment, whichever is less, unless they can't afford it, in which case the city pays everything. The state's laws differ on financial obligations, or financial limits of the claims. The New Mexico statute, as we've heard, has a $2 million cap. The Colorado statute doesn't have statutory immunities or damages caps. They differ on the obligations to collect information about these cases. New Mexico's laws, we've talked about, has this obligation to collect information about settlements and judgments and complaints. There's nothing comparable in the Colorado law. And the states differ on which government employees they cover. New Mexico covers all government employees. Colorado's law applies to law enforcement. Mark asked during their panel what I thought of the critique that New Mexico doesn't allow naming individual officers. I understand where that critique is coming from. I understand the value of the psychic, perhaps, value of having a judgment against an individual officer or having an individual officer named in the complaints. I also think, though, that in naming those individual officers can lead to some real confusion among juries about who's actually going to pay in these cases in the world where officers are virtually always indemnified. But more importantly, I really take to heart what the prior panel said. That was the legislation that could be passed. And that was a meaningful compromise to be able to make to get this bill passed. And in my view, a passed bill is better than one that never got passed at all, even if that other one might, in some carry some more idealized form. So I prefer the bill that gets passed to any other bill. And looking at New Mexico and Colorado statutes, which were both passed, I don't aim to convince you here that one is better than the other, that one has optimally adjusted the various knobs at their disposal, or anyone should adopt one or the other of those laws. There's going to be disagreements among states and probably disagreement in this room about what the best way is to adjust those various knobs. My goal for you and for other states, if they're listening, is to focus not on trying to flip the qualified immunity switch, but instead think about adjusting these various different knobs to achieve the balance that they consider to be right. Lesson 3, legislation is just the first step. In recent years, it has proven extremely difficult to pass police reform legislation that makes it easier to sue for government officials for constitutional violations. Since 2020, more than half the states have introduced legislation like the legislation that was introduced in New Mexico. And almost all of them have been tabled or voted down. New Mexico, Colorado, and New York City are the bright lights here. And I've already learned some valuable lessons about the secrets of the New Mexico Civil Rights Act's legislative success in the face of so many other failures, and I'm going to leave it to those who have been closely involved in the passage of New Mexico statute to advise other states' legislatures about how to capitalize on those insights. But the lesson that I want to emphasize is that passing the bill is just the first step in a far lengthier process to understand and interpret its provisions. This is a legislation that has adjusted several knobs, but in the future months and years, the implementation of that legislation is going to calibrate those adjustments further. As we've talked about today, there are going to be questions about the ambiguous provisions in the statute that need to be understood and construed. We've already heard questions about the statute of limitations and about how the $2 million damages limit per claim applies. There are many more, including Seth Montgomery, who's here, and Isaac Green. They're writing an article for the symposium that examines the scope of New Mexico Civil Rights Act's attorney's fees provision. It says that the court shall award reasonable litigation expenses and attorney's fees for all work reasonably necessary to obtain a successful result to any person who prevails in a court action to enforce the provisions of the New Mexico Civil Rights Act. So Montgomery and Green are questioning what it means to prevail in a court action, and specifically whether a plaintiff prevails, entitling them to attorney's fees when their case settles. Section 1988, which is the attorney's fees provision for federal civil rights cases, has been limited by the Supreme Court to cases where plaintiffs prevail after trial. But Montgomery and Green are arguing there's no sensible reason to limit awards of attorney's fees to those small sliver of cases that happen to go to trial, where plaintiffs win hard-fought victories through settlements. And New Mexico courts have latitude to reach a different conclusion on that point. New Mexico courts also have latitude to reconsider the scope of, and consider the scope of the New Mexico Constitution. We've heard before about, earlier today, about possibility of reconsidering the New Mexico statute to have an affirmative duty to protect, and a duty that the United States Supreme Court has held not to be a part of the United States Constitution. That's a topic of another contribution to the Law Review Symposium. And I'm sure that there will be many more questions. But those questions, those legal questions inspired by passage or being posed only because passage of the Civil Rights Act are going to shape its effects moving forward. I'm sure there will also be ways in which other aspects of the civil rights ecosystem shifts over time in response to the Act. Attorneys might be more willing to accept civil rights cases or to accept cases that they wouldn't otherwise have accepted. Local governments may change the ways they budget for and pay settlements and judgments in these suits, or was mentioned in the prior session, might affect the way they think about risk management, about training, and about hiring their officers. Insurers may adjust their, thank you. I have a cough that's, I'm fine, I just can't stop coughing for months. Insurers might adjust their premiums in response to rising litigation costs. And the Act's provisions requiring local governments to track information about these allegations and outcomes may also inform decisions. And each of these changes, if they come to pass, may influence other decisions by local government and their attorneys and their insurers and their policymakers. Our ecosystems of civil rights litigation are perpetually adjusting everywhere in response to shifts of politics and national events and the economy and legal rulings. And in New Mexico, the Civil Rights Act shifted several aspects of the ecosystem all at once. But the symposium that we're having here today and articles published by the Law Review make clear that these knobs of reform are going to continue to be adjusted for years after this legislation's been passed. And the final lesson, lesson 4, follow facts, not fear. When doing the difficult work of crafting and passing and implementing and evaluating accountability legislation, it is incredibly important to be guided by facts and not fear. And this is why I think many states have failed, where New Mexico succeeded. I think in many states they have been guided by fear and not facts. To listen to opponents of police accountability legislation, there is a great deal to fear, and it's very scary. I've participated in legislative hearings in states across the country that have taken up bills similar to that enacted in New Mexico, and in those hearings, union officials and government attorneys have argued that if it's made easier to sue, courthouses will overflow with frivolous cases filed by nefarious civil rights attorneys. If officers are going to be bankrupted for good faith mistakes made in a split second, no one is going to agree to become a government employee given those risks, and chaos will ensue. Union officials and government attorneys offer no evidence to support these claims, but they have been frightening enough to doom police accountability bills introduced in more than half the states across the country. And I know that there were some similar arguments that were made in New Mexico. After the legislature created the Civil Rights Commission and tasked it with recommending whether to enact a statute prohibiting qualified immunity for state constitutional claims, the editorial board of the Albuquerque Journal described in stark terms the dangers they imagined were associated with removing this protection for the police. This is what they wrote. Do we really want a simple negligence standard to apply to the split-second decisions officers have to make in potentially dangerous situations? Do we really want to take a rookie Albuquerque Police Department officer working graveyard in high-crime Albuquerque, making maybe $60,000 a year, and put his or her house on the line for doing something in response to a 911 call that in 2020 hindsight might have been done better? This is unquestionably a frightening picture to paint, but it bears little, if any, relationship to reality. And today, or before the commission was convened, for one, getting rid of qualified immunity does not mean that you are then left with a simple negligence standard. For two, officers in New Mexico were and continue to be indemnified for their conduct. So an Albuquerque officer making $60,000 a year would not be putting their house on the line. Third, the idea that qualified immunity is what protects an officer from a mistake that, quote, in 2020 hindsight might have been done better, ignores the existence of the Supreme Court's decision in Graham versus Connor that sets the Fourth Amendment use of force standard and says specifically, when deciding whether a constitutional right has been violated, you do not rely on 2020 hindsight. Instead, you look at what the officer has done in the moment under the totality of the circumstances. And the Supreme Court's decisions have repeatedly said that officers can make mistakes and not violate the Constitution. So this is a frightening story, but it does not tell a story that is reflected in reality, and it does not tell a story about why we need qualified immunity. 5 days of hearings and public comments and deliberation by the commission led to a majority vote to recommend several provisions that became the Civil Rights Act. And accompanying their recommendations was a report that's been applauded earlier today and should be applauded again. It was filled with evidence and analysis about the current state of Section 1983 law, the current state of New Mexico law, legislative activity across the county, and a special mention to attorney, now judge, I hear, Catherine Ray, of almost 1,700 federal civil rights lawsuits that were filed in New Mexico and that made clear that qualified immunity was the reason just a small percentage of those federal claims were dismissed. In recommending passage of the Civil Rights Act, the New Mexico Civil Rights Commission, in my view, chose facts over fear, and the legislature did so as well. And so did the governor, who signed the bill into law. As she explained when signing the bill, in response to some of the commentary surrounding this measure, I will say this is not an anti-police bill. This bill does not endanger any first responder or public servant so long as they conduct themselves professionally within the bounds of our Constitution and with a deep and active respect for the sacred rights it guarantees all of us as New Mexicans. A common concern of the Civil Rights Act, and one that we've heard today, is that it would impose too many costs on local governments. When these fiscal concerns were raised to the Civil Rights Commission, the Commission evaluated the available data and concluded the act was not actually, quote, the seismic shift some have portrayed and will continue to portray. In reaching this conclusion, the Commission relied on evidence that ending qualified immunity would not vastly increase the number of suits or payouts, and many provisions in the act are not new. Attorneys' fees are already available, officers are already indemnified under state law, and punitive damages can't be awarded pursuant to the act. It's my understanding that in February of this year, legislation was introduced to do away with the act, again based on concerns about increased litigation and negative effects on officers and departments. But after the legislature's fiscal impact report determined the act was not actually causing the feared increase in settlements and judgments, and that instead there had been no verdicts or settlements under the act 2 years after its passage, based on the data that they had, the bill was tabled. Now, I'm not arguing that the New Mexico Civil Rights Act should never be reconsidered, or that the conditions or the concerns that have been raised would never be valid under any circumstances. Instead, my point is that we should be guided by data, by the realities on the ground, not by myths and misrepresentations that sound frightening but have no basis in reality, particularly when doing so would require victims of government misconduct to bear the costs of their own constitutional violations. These are costs no matter who pays for them. When the Commission first entertained concerns about the fiscal impact of the act, it noted the legislature had dealt with these types of concerns in the past by, quote, going forward thoughtfully, observing how a statute operates, and readjusting when the facts show it is necessary. This is what New Mexico has done thus far with regards to the Civil Rights Act, and I hope it is what New Mexico continues to do. And I hope that other states have the courage and confidence to follow New Mexico's evidence-based approach if and when they consider similar legislation. In its 2020 report, recommending, see, I've been reading it myself, recommending passage of the New Mexico Civil Rights Act, the Commission quoted Justice Louis Brandeis, writing, quote, "It is one of the happy incidents of the federal system that a single courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risk to the rest of the country. By passing the New Mexico Civil Rights Act, New Mexico has established itself as just this kind of laboratory. Legislators, judges, lawyers, and advocates across the country are, or they should be, watching. And I hope they take to heart the lessons that your experiment has revealed. Qualified immunity is just one piece of the puzzle. Reforms are knobs, not switches. Legislation is just the first step. Follow facts, not fear. And I hope New Mexico continues to heed these important lessons as well. Thank you. I guess we have some time for questions. There's a question over here. Oh, I've already called on something. That's the professor in me. Sorry.
Thank you for being here, and I found your remarks to be very insightful. I practice primarily insurance defense for government entities, and I'm curious about two things. One, is there, as we've heard today, the ability, let me restate that. There has appeared today to be a concern about reformation of certain practices within departments or within government agencies, such that it prevents certain constitutional violations from occurring in the future. Is there a concept that anybody has thought about or described or discussed or debated where maybe if there is a plaintiff who is successful in proving that somebody has violated the Civil Rights Act, where part of that judgment or that victory could be carved out, a percentage for say, to be able to be applied to either a risk pool or to some type of management authority that could then use that to actually retrain. If the intent is to truly not just make money for plaintiff's counsel, which I know none of my friends who are plaintiff's counsel in this room would ever say that that's their sole intent. But if there is a desire for there to be a part of that particular decision for reformation, has there been ever any discussion about contributing a portion of that particular victory towards something in that regard? And then two, I'm just really confused about things because I've heard things, I've done this for 26 years now, and I've heard things about the passage of the act that it has nothing to do with qualified immunity, but then when you look at it, the discussion about qualified immunity keeps coming back through. New Mexico never recognized the doctrine of qualified immunity in state court law. Never existed before this, and it still doesn't exist, and now it's specifically prohibited as being a defense to the Civil Rights Act. The only thing we have is a doctrine called privilege, and that primarily comes out of the idea where an officer is privileged to conduct certain activities so long as they're doing it within the course and scope of their authority and they are acting reasonably. And yes, the courts in New Mexico have said that they do look towards the Graham v. Connors standard in that respect. They don't necessarily have to apply, and specifically, Judge Ray's decision in the most recent, I think it's the Valenzuela case, that said, you don't get to come into New Mexico court when a case has been remanded after maybe qualified immunity has been granted in federal court. You don't get to come in and ask for res judicata or collateral estoppel as to the state tort claims or any other type of claim, because the doctrine of privilege uses both a subjective and an objective standard. So my question is qualified immunity was never part of the New Mexico lexicon to begin with, and so therefore it doesn't appear as if it's something that can be dialed in terms of rotating the knobs as far as fixing the New Mexico Civil Rights Act, because it's been prohibitively, stated in there. So I'm wondering, am I just dumb, which is possible, and not understanding the history of New Mexico civil rights law and how it affects things prior to the passage of this and subsequent to the passage of this? Or am I correct in saying that it's kind of a red herring to think that qualified immunity is a problem in New Mexico or ever existed as a problem in New Mexico law? Because it didn't exist as a doctrine prior. So my two questions are, can you contribute something from a plaintiff's recovery to the reformation of a department or something? And then secondly, I'm just looking for clarification on the qualified immunity issue. Thank you.
Sure. Great. So I do think that when you hear from families or other victims, often they say they want two things. They want to be made whole, they want some compensation, some recognition of what happened, and they want to prevent something similar from happening in the future. I know of many examples of cases where there have been negotiated in settlement agreements, not just compensation, but policy changes moving forward. And there are many attorneys who I've spoken to who work to add in policy changes to settlement negotiations, to settlement agreements. I can't tell you what the terms of those settlements would be absent those policies. I don't know that there was a formal exchange of dollars for policy changes. But I certainly know that in settlement agreements, there is often the desire to do both of those things that are effectuated in the terms of the settlement agreement. Or basically, I sort of bristle at the idea that a person whose rights have been violated, who has lost a loved one, or who have had their lives forever changed, must pay from their own, most personally bankroll efforts to improve the police department so that it doesn't happen again. In my view, they've already paid enough and shouldn't have to carry that extra cost. But, you know, I do think that, despite that, I think that there are families and people who, you know, who do incorporate that into settlement agreements. I'll also say, because you work with insurance companies, I've done some research about insurers, and you know what I've found, and this hasn't come up as much today, is that insurers can play a really valuable role in doing this risk management themselves and in changing policies themselves. I spoke to the risk manager for the Idaho sheriffs, who works with all of the pooled insurance for Idaho, and they said that after there were a bunch of lawsuits in their jails, they came up with a list of 8 policy changes, 8 policies that all of the jails that they insured had to have, and I can't remember what they all are, but I remember 2 of them. One, they needed to have a nurse or other medical health provider available, and one was that they needed to have more than one person on staff at a time. And what the insurance company said is, look, we know that these are issues that result in claims. You all have to make these changes within 2 years, or we're going to increase your premiums or cut you off. And almost all of the departments, the sheriffs, the jails made those changes. And so I think that insurers, because of the liability risk, can be a real catalyst for valuable changes here and everywhere. And I hope that insurance companies, insurers take that high road, you know, of trying to prevent the harm from happening, as opposed to, I'd like them to spend less time fighting the claims and more time preventing them from happening in the future. As far as the qualified immunity not being a problem in New Mexico, I will leave that to the practitioners in New Mexico, perhaps to answer this question more completely than I could. But, you know, my understanding is that state law, before the New Mexico Civil Rights Act, did not provide a complete or comparable remedy for people. There was the Tort Claims Act, which we've heard about sort of all the gaps in that act. There was presumably sort of state, those state tort remedies which did not reach what the Bill of Rights, the New Mexico Bill of Rights reaches. And so people absent the New Mexico Civil Rights Act were left with a federal constitutional claim under 1983 where qualified immunity did exist, and the state tort statute, which was incomplete and didn't allow for these claims to be brought, or you know, some portion of those claims to be brought. And I think hearing the conversation this morning, there has been multiple examples of cases where qualified immunity truly did matter and create an impediment. As I've said, I don't think that qualified immunity is the whole problem, and I think it's a mistake to make qualified immunity the headliner issue when we're talking about police misconduct. It certainly does result in many, many outrageous cases, but I think it is a broader set of issues, interlocking issues that we need to address, and qualified immunity is not the only one.
Thank you, Professor Schwartz. My name is Israel Chavez. I'm an attorney in southern New Mexico. I want to note that, you know, I live and work and practice in the community I grew up in. My family's been there for more than 11 generations. And I really appreciated the point that, like, not all plaintiffs' lawyers think this way, but for me, you know, I have ongoing litigation under this act. I do want the police departments to do better, and I want to note that people of color bear the brunt of the violations, but when you look around the room or you look at the panels, in a state like New Mexico, none of that looks like our state. And pretty disappointing, I gotta say, but nonetheless, when I file a lawsuit, I do that with knowing that my father's been pulled over like 5 times in his 96 Toyota pickup for like super minor non-violations, and I know what they're doing, right? So for me, I would like to hear, like, in a perfect world, if you could wave a wand and do 3 or 5 things in a department today, right? What would it be? I mean, where would you start? Because I'm interested in that conversation, even though I'm probably going to do okay under this new law, under these, because the police departments in southern New Mexico are so bad. I am committed to also fixing it generally.
Thank you for the comment, and I love that magic wand. Boy, I would love to have that magic wand, but it does raise some questions about, you know, what you might do. The last chapter of my book is called A Better Way, where I make a bunch of recommendations.
I'll buy the book.
Oh, no, I have a point. This isn't me shilling. But that sort of talking about changes to state and local governments that could make things better. But I've been working on this little extra essay that was called, for something else, you don't have to buy it, it's free, called An Even Better Way. And what I talk about is this colleague or friend, Fred Smith, who teaches at Emory, said, you know, boy, all these changes are great. It'd be great if I got shot and I could now bring this case in court and win, but wouldn't it be better if I didn't get shot in the first place? Like, that's the even better way. And so I think that if I had that magic wand, my 3 to 5, taps of the wand would focus on that. And of course, more effective litigation, as we've talked about today, can lead to some of those changes. But in an ideal world, you don't have to go through the litigation. You can prevent the stuff from happening on the front end. You know, I think that there are interesting conversations happening around the country about how to limit police interactions with people. There's a lot of jurisdictions around the country that are starting to experiment with having unarmed mental health professionals respond to people who are in a state of mental health crisis. And this is an interesting, I don't even know if I need the magic wand for this, because it's actually a topic about which law enforcement and advocates and folks who say defund the police and fiscal, conservatives can agree upon, because it actually saves money. Officers don't want to, not this is generalizing, but like in Los Angeles, the Los Angeles Police Union came out and said, we don't want to be responding to non-golf calls anymore. And so I think there's a way in which you can actually get some shared agreement over that idea. And I think that reducing police interactions is sort of the most powerful first step to take. There are other conversations happening in other parts of the country about eliminating police involvement in traffic stops, to your direct point. We now have, if you go through a red light, there can be a red light camera that, takes a picture of your license, license plate, yeah, and, if someone was speeding or they had a broken taillight or whatever else it is, why not pull someone over, take a picture of their license plate, and send them on their way without having to get out of the car. It would save officers' concerns about safety, and it would keep people more safe. So those are the kinds of changes that I think if I had a magic wand, I would wave it.
Thank you.
If there's one more question, it sounds like we have time for one. There's someone way back here.
My name is Michael Ashman, I'm the county attorney in Sandoval County. I'm on the board of the County Insurance Authority, which provides insurance to all 33 counties. And you spoke about insurance companies forcing a change. Well, the pool has reinsurance contracts, and when the Civil Rights Act came into place, the reinsurers specifically excluded they will not cover one penny of these claims. So the insurance companies we're dealing with, all big, sophisticated, multinational corporations, won't even touch the act because they think it's so, the risks are too great for them even to insure.
So this is really interesting, and I actually would love to speak to both of you who work with insurers and anybody else who does at some point today, because this is something I want to know much more about. I, with a couple co-authors who also testified in the commission, are working right now to try to measure how many cases have been brought under the Civil Rights Act and under the Colorado's Act, and what's happening in terms of payouts in these cases. And my sense thus far, and again, this is, we're just in the beginning stages of this process, but my sense thus far is that there have not been an increase in settlements and judgments in cases since the act was passed. And the sort of fiscal sky has not fallen in the way that was described, but that insurance rates have increased significantly. And I don't know, I don't understand, which is why I want to speak with you, what the lever is, what the possible response is. I don't think that the answer can be insurance companies raise their rates for costs that don't exist, therefore we should get rid of the Civil Rights Act. I want to understand how it is that insurance rates are going up for costs that haven't materialized yet, and understand how this can be, and whether and how to consider possible adjustments. I know that the commission predicted the possibility that rates were going to go up, and in the commission's report, there was a variety of different possible steps that might be taken were that eventuality to happen. But absent evidence that these cases are resulting in significant new liability, I think that this is going to be one of those aspects of the process that are going to have to be continued to be adjusted, and perhaps further advocacy around.
What is the most recent year that you're facing the increase in insurance rates?
I mean, the data that we're collecting is going through this through 2023.
Insurance rate went from $10,000 a year payment to nearly a year because we actually one officer and one settlement. So I think there are good solutions.
But was it under the Civil Rights Act? I don't think it was either. I don't think there's. I don't need to observe that it was.
Professor,
Hmm?
may I ask?
It's up to Chanel. She's.
This will be our last question. It's not really a question. It's a suggestion. Inspired by what occurred today, particularly Mr. Chavez from Southern New Mexico and the people from the management industries. I know you're a professor of law, and I look forward to this coming out, and I too will buy your book. But have you considered, I'm going to call it a talking tour, where you actually, you and maybe some of your students, go from police agency to police agency across the state of New Mexico and actually engage some of those officers and administrators in a dialogue and ask them, how do they feel since the passage of this act? What's their perception of its impact on their job? And then educate them and really, address their concerns. Because if I had to mention one, I require all police officers to have like 30 hours of a liberal arts education, including mediation. I would implement an Inspector General program, like the one I have in Los Angeles, the city of Los Angeles, run by Max Huntsman. And I would have wellness classes for officers so they can learn to self-gauge when they've had too much and they're about to explode. Or they have PTSD and they've been recruited because they have a military background and they're not accessing veteran services and they need something that's right there in the police department to help them. So, but I loved your talk. I learned a lot. I took notes. And I feel like if you went using this language, very accessible, facts, not fear, nods, not switches, and had that kind of dialogue, I think it would be very helpful. And again, I know you're a professor, my big sister's one too. and you publish and put out academic journals, but this is a street level issue. This is and I hate this phrase, boots on the ground problem. So if you'd be willing to put your boots on, hit the ground, and talk to local cops, and I think you could really make a big difference. And that's all I have to say. No questions.
Okay, thank you, Professor Schwartz, so much for